Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons for the business for the Honorable United States Court of Appeals for the Fourth Circuit. I want to draw an act to get their attention for the court is now safe. God save the United States and this honorable court.
All right, please be seated. We're prepared to begin in our first case, United States versus Devine and Mangum. And Mr. Ashton, I believe you're up first.
I am, Your Honor. Thank you. May it please the court, I'm Rudy Ashton. I represent Brandon Mangum. My co-counsel is Dean Lester. He represents Demetrius Devine. I'm going to address arguments 1 and 2 because they pertain solely to Mr. Mangum, and then we're going to both address the very high sentencing issues. Brief facts are this is basically a gang racketeering drug murder case out of Raleigh, and it had 2 controlling events, one in November of 2008 involving the death of Darius Fowler, and that involves counts 1, 4, and 5 for Mr. Devine, and the second on May 25th in 2009 regarding the death of Re-Up Burrell.
Counsel, the panel is going to be familiar with the facts, so if you want to save some time, you can just go right to your argument.
Yep, I will. I just want to narrow in. There's really only 2 events that control these massive sentences.
Well, let me ask you this. Are you objecting to multiple convictions or just to consecutive sentences?
Argument 1, objecting to multiple convictions on some of the cases and multiple sentences on all of them.
I asked you the convictions, which one?
In particular, one of our arguments is that the count 6 drugs, which involves both of the defendants, is subsumed in the RICO conviction because it's a racketeering act that had to be found separately. And in Mr. Mangum's case, we of course argued the insufficiency of the evidence on the drug case because of basically sporadic mere buyer-seller relationships over a number.
Well, to prevail on your claim, don't you need to show that there's insufficient evidence to support either the drug dealing charge or the Burrell murder charge?
Well, correct. And as I say on the on the drug charge, where the basic argument is it was just sporadic sales over a long period of time, and really was not part of the RICO conspiracy or the enterprise. And the other thing is the identification of.
But he's charged separately for the RICO conspiracy and the distribution and possession conspiracy. It's 2 different charges, correct?
Correct. Yeah.
So why couldn't he be convicted of both?
Well, because we're taking a position that the RICO acts are subsumed in the.
So is this a double jeopardy argument? Or
that would be more double jeopardy. The double jeopardy goes to cumulative punishment, not a brutal.
But as far as RICO is concerned, you're questioning the evidence to support the 2 racketeering acts, and with respect to the drug dealing, weren't there a number of co-conspirators that testified that the gang was organized around drug dealing activities, that they control the territory, and for example, the lesser figures in the gang were not permitted to make drug deals until the major figure in the gang, Mr. Devine, had finished his sales for the day. And there were also several members of the conspiracy, as I understand it, who personally testified as to Mangum's personal drug dealing activities. So whether you're dealing with the drug dealing conspiracy as one, or whether you're dealing with the RICO conspiracy and a racketeering act, isn't there a good deal of evidence that drug dealing was an important source of revenue for this gang, and indeed one of its organizing principles?
Well, the facts are they are. We try to lay it out brief as best we can, but there certainly was, and that goes to the second argument. There was a lot of evidence, great disparity of evidence against Mangum and against Devine, and Mangum's lawyer did file a motion to sever, and that was the basis of that. Basically, the disparity of the evidence there. There were 37 overt acts. Only 3 dealt with Brandon. 24 of them dealt directly with Demetrius Devine.
So you're now talking about the motion to sever?
Yes, because again, that sort of feeds off the insufficiency of evidence, because most of the evidence we contend, or the great majority of it, is against Mr. Devine.
Why would the district court have severed the cases when they were both defendants were indicted together, and they were both high-ranking members of the same gang, one being a 4-star and one being a 3-star? And then the trial judge was very careful in saying, you've got to consider each defendant separately, and he told the jury that.
Well, I think we agree, Your Honor, that both parties agree that the Farrow case is a seminal case, and of course it ruled for the government that joint trials are preferred. But our position is it did warn that could be a markedly different degree of culpability.
But as to that culpability argument, haven't we rejected that argument in Zelaya, Zelaya? Didn't we reject that argument on different degrees?
To some degree, but I don't think it went to quite the effect here. But moving on, and Mr. Lester will follow up on this, is the basically the 2 young men. They were young at the time all this happened. My client was in his early 20s, and Mr. Lester's client was in his mid-20s. And they basically each got 3 consecutive life sentences for one event, the Fowler event and the Burrell event. And so where we're approaching it from double jeopardy standpoints, as well as the multiplicitousness, is the cumulative punishments for the same offense.
Are we to view it as those 2 events alone, or all the other? They both had fairly significant histories of criminal activity that was fairly severe.
Well, in most of the research we saw, most of the persons that got multiple sentences for this type of activity had multiple events, like several murders and several different things. In this case, they basically, the Burrell murder led to 3 life sentences for.
Well, the question in this, I thought, was a pretty settled proposition of law, which was that you could have consecutive punishment as long as it was for a separate statutory scheme. And that there's a good deal of law out there saying that that's permissible. And of course, when you look at the RICO conspiracy and Vicar, for example, those are separate offenses. They don't have the same elements. And as long as they're separate offenses, why would there be any double jeopardy. I thought this was one of the more settled propositions.
Well, it's very confusing. If you go just with the elements, I think there's a problem. We also consider that Vicar is
We do other
is more
with
an
the
enhancement
elements.
of the RICO sentence, and that the 924J is more wouldn't even apply because there's a larger maximum minimum sentence under Vicar, which is automatic life. And therefore,
I mean, there it was separate as well, because you had one sentence for the crime of violence, and then you had another one for causing death by the use of the firearm during that crime. So they seem separate there. But at any rate, you have some time for rebuttal, and if there's no if my colleagues have no questions for you, we'll turn things over to Mr. Lester.
yes, I'd like to do that. Thank you.
May it please the court. My name is Gene Lester. I represent Demetrius Devine. Without conceding the point by Judge Wilkinson that there is settled law with respect to double jeopardy here, I want to talk about, assuming arguendo that the court could issue consecutive or multiple punishments. I want to address the issue whether they should have under the 3553A factors. And I'm asking.
So this is a sentencing argument, not a conviction argument.
That's correct, Your Honor.
All right.
And I'm asking the court to remand this case for resentencing to consider a sentence that is sufficient but not greater than necessary. And we contend that 4 life
So
sentences.
your argument is it's substantively unreasonable,
Yes, Your Honor.
not and that there's no argument here about any procedural reasonableness.
That is in the brief, and that is what Mr. Ashton was addressing with the court. But assuming arguendo that there is no procedural error with respect to the sentences or the guidelines or the statutes, then we have a substantive unreasonableness argument. And under 3553A, as this court knows, the sentence must be sufficient but not greater than necessary.
Well, you know, one of the things that your client could have done to help himself out was to accept some sort of responsibility. But at the sentencing hearing, Mr. Devine, as I understand it, absolutely refused to accept responsibility. As Judge Agee pointed out earlier, you know, we're not dealing with shoplifting here. We're dealing with a gang that didn't hesitate to resort to murder when someone got out of line. And the whole Mr. Devine led this gang, and the gang had a long history of violent crime. And the other thing he was doing is that he was continuing to lead the gang even when he was incarcerated for Mr. Burrell's murder. And so there's no evidence here of contrition, that incarceration made no difference in his conduct. And he was, when given a chance to accept responsibility for what he did, he declined. And the court explained all of this in terms of the need for incapacitation, which seems obvious, and deterrence. Why would we hold this to be, if it was procedurally sound, why would we hold it to be substantively unreasonable?
Yes, Your Honor. There are additional facts in the PSR that were not considered by the district court with respect to the history and characteristics of this defendant, Devine. In the joint appendix on page 1930, beginning in paragraph 69, the Devine defendant said that as a youth, he felt like an outcast. He was overweight as a child. He suffered from a speech impediment. All of these things contributed to his criminal activity. Paragraph 72, he was stabbed 2 times in jail. He was grazed by a bullet in the abdomen. Paragraph 74, he was addicted to marijuana since the age of 14. Paragraph 76, the PSR, he had completed special education classes in school. He was unable to finish school. He was last in his class. All of these histories and characteristics contributed and ought to have been considered by the court, at least under the case in Freeman, and also under the case in Howard, where the court must consider the history and characteristics of the defendant in addition to the things that you've mentioned, Judge.
Well, in the cases where the life sentence was imposed, did the judge have any discretion?
I'm sorry.
Did he have any discretion to go lower?
In this case, the judge did not have discretion with respect to the Vicar count. The Vicar count requires mandatory life. The other sentences were not required to be life. And I'm arguing that a life sentence is sufficient, but not greater than necessary to reach the goals of incapacitation, rehabilitation, and deterrence. That this defendant only had one life to give. And any sentence that's greater than that, in this case, without there being discrete acts in addition to the conspiracy.
Well, as to the Vicar sentence, if he can't be released, what are the adverse consequences stemming from the additional life sentences?
Well, they're not. It's not a rational sentence.
I'm not arguing about that.
Yeah, the adverse. I think it suggests that retribution is the primary focus here, which is not an appropriate focus for punishment. It's not one of the justification for punishment that's been identified in the Supreme Court in the Davis case. The rationale for punishment, and I think it violates the 3553A statute that Congress requires the court to consider, which is the parsimony clause, a sentence that is greater than, but not is sufficient, but not greater than reasonable. And so in that way, I think there's a legal harm here.
All right, thank you very much, sir. Thank you. Judge Floyd, do you have any further questions? I didn't mean to cut you off.
No, sir.
Judge Agee?
No, sir.
All right. Is it Ms. Fritz? We'd be happy to hear from you.
Thank you, Your Honor. Good morning. May it please the court, Christine Fritz on behalf of the United States. With me at council table, I have the United States Attorney for the Eastern District of North Carolina, Mr. Michael Easley Jr., and also the United States Attorney for the Western District of North Carolina, Ms. Dina King. Ms. King was one of the two attorneys who prosecuted this case in the district court. Thank you for giving us permission to have them here.
Can you tell me before you get started down your road, is there a reason you did not brief harmless error on the double jeopardy argument?
I don't think that we would be able to brief harmless error on the double jeopardy argument because each sentence carries its own special assessment. So each sentence has an additional punishment regardless of whether they're ordered consecutive or not. So if there's a double jeopardy problem, the simple fact that there are sentences for each count of conviction and the sentences all carry additional monetary penalties thwarts any effort for the government to argue harmlessness. But I'd like to start with the double jeopardy argument. And I think that what this comes down to is the double jeopardy clause penalizes legislatively unauthorized.
Well, is it your understanding, counsel? Let me start over. From what I've gleaned from opposing counsel's argument, they are not contending that the multiple convictions violate double jeopardy. Their argument is that there's a double jeopardy barrier of some sort because of the multiple sentences.
Correct.
All right.
And because there's sentences on each count of conviction, our position is that whether they had been run consecutively or not, because they all are accompanied with an additional special assessment, we're not in a position to make a harmlessness argument. And I believe that I cited a case in our brief for that proposition.
Right. Well, as you go to the argument that they've made that having the multiple life sentences constitutes some type of double jeopardy.
In terms of the double jeopardy problem, as opposed to substantive reasonableness?
Well, it's kind of hard to differentiate them from what I've heard so far. So do your best.
Okay, well, I actually think that it is helpful when you can differentiate them. They are different. I see them as being very different issues. Double jeopardy clause prohibits, in the context of a single prosecution, multiple congressionally unauthorized punishments. And here we have Congress having authorized multiple punishments for these offenses. And we know that both through the Blackburger analysis, when we compare the elements of the offenses, because each of these offenses contains an element that the others does not. Beyond that, we know from Congress's intent. And turning to the Blackburger analysis first, a RICO conspiracy requires an enterprise affecting interstate commerce, each defendant's knowing and intentional agreement to participate in the affairs of that enterprise, and then the agreement to do so through a pattern of racketeering activity. That means that each defendant knowingly and willfully agreed that he or a co-conspirator would commit at least 2 racketeering acts. Once that agreement has been reached, the crime is complete. And I believe that this court's Simmons opinion is illustrative in terms of analyzing the elements of the RICO conspiracy, because in that case, the court looked at the third element, which was the pattern of racketeering activity, or the 2 or more predicate acts. And what it said was that the acts that are listed in 1961 are effectively means of proving that element. So it simply cannot be said that every single RICO conspiracy involves drug trafficking or involves murder. If every single RICO conspiracy does not involve drug trafficking or murder, it cannot be said that the drug trafficking or murder are elements of the RICO conspiracy.
Well, typically separate convictions for a RICO conspiracy and the predicate offenses don't pose a double jeopardy concern, but here the RICO sentence was increased to life because of the very same predicate offenses, the murder for Mangum and the murder in large quantity of drugs for Divine. Is that a problem?
No, that is not a problem, because it comes back to the fact that these aren't elements. The murder is not an element of a RICO conspiracy, and similarly, the drug trafficking is not an element of the offense. And when we're doing the Blackburger analysis, we're focused solely on the elements of the offense, because it's clear that Congress may choose to penalize the same conduct in different statutory schemes. And here we have Congress having chosen to create different crimes: the RICO conspiracy, the Vicar, the 924C, 924J, and also the drug trafficking. We also know, if we turn to the Congress's intent, we know exactly what Congress's intent was when it created RICO. It wanted to create increased and enhanced penalties and new weapons for law enforcement to combat organized crimes. And in this court's opinion of Ayala, I may not be saying that correctly, but that's a case where it explored the relationship between the RICO statutes and Vicar statutes. And this court has explained that they are complementary, but they're ultimately directed, it's Congress's intent that they're focused on different evils. The RICO statutes are focused on the organized crime, but then Vicar is focused on those individuals who are willing to engage in violent acts to gain membership or increase status or maintain a position within those organizations. So it's entirely appropriate that Congress wanted there to be multiple convictions and multiple sentences for these acts.
So do you think Ayala is dispositive here or merely instructive?
I think that it would be dispositive of the Vicar related offenses. I think it is also instructive as to how to go about analyzing the drug conspiracy. I think that when you look at the congressional intent and you look at the the different evils that are sought to be remedied through the statutes. Again, we go back to RICO being the organized crime, and drug trafficking, obviously it's in a completely separate title, and it is directed at, the narcotics activity. And additionally, RICO is very clear when it says that these punishments there were new punishments to be intended. And the Supreme Court said in Rosello that Congress clearly demonstrated that the RICO statute was intended to provide new weapons of unprecedented scope for assault upon organized crime and its economic roots. When RICO was enacted, obviously the drug trafficking statutes were already on the books. So I think this again goes to Congress's intent, whether you look at it through the lens of the Blockberger analysis and the elements of the offense, we maintain that these are all separate offenses.
Well, is a drug conspiracy a lesser included offense in a RICO conspiracy after the Wayland case?
The Wayland case doesn't come to mind.
Well, it held an offense can constitute a lesser included offense, even if it overlaps with only one of the several offenses listed in the multipurpose statute. That is, if you prove RICO conspiracy based on a drug conspiracy, you by definition prove the drug conspiracy, even if theoretically you could prove the RICO conspiracy based on some other predicate act.
They can certainly, the same conduct can give rise to multiple offenses. But at core, the elements of the offenses are different. And I have to come back to this court's opinion in Simmons, where it talked about, the element of RICO conspiracy. The third one, which is I think the one that we're most focused on here, is that the defendant knowingly and willfully agreed that a co-conspirator would commit at least 2 racketeering acts. And then the statute goes on to list a myriad of means of establishing that element. And Simmons, obviously, it's in a slightly different context. It's in a categorical approach where the question was whether the RICO conspiracy had as an element the attempted use or threatened use of force.
So what you're contending here is that you have 3 different conspiracies: the drug trafficking conspiracy, the RICO conspiracy, and the Vicar. And you're saying each of those is different. Each one of those is different from the other.
Yes.
And if Congress created RICO conspiracy and Vicar and the drug trafficking conspiracy with different aims in mind and with different elements, then you can't have a double jeopardy claim because they're separate offenses. And double jeopardy refers to multiple punishments for the same offense. But your argument boiled down seems to me that these are not the same offense. They're separate offenses, and each one of them is aimed by Congress, and the bills were passed by Congress with a different ill and a different set of criminal elements involved. And that's what I understand your basic argument to be.
Yes, Your Honor, that is our basic argument, and cases from this court support that position.
Yeah, I mean, if you have separate offenses passed by Congress for different reasons and with different elements, you don't have a double jeopardy claim, because there's so many cases out there which says cumulative or consecutive punishment for separate statutory offenses is not a double jeopardy violation. And there are a legion of cases that say that in this circuit and elsewhere.
Yes, Your Honor. With respect to the other sentencing issue, the substantive reasonableness, the case law is clear that this court has to affirm any reasonable sentence, and that there may be other reasonable sentences, and this court might have chosen to impose a different sentence. But at the end of the day, the sentences imposed on these defendants were reasonable.
Now tell us why. Go into this history of violence that this particular gang has perpetrated. Just say, go into the activities of it. And I guess Mr. Devine is the one that's raising this substantive reasonableness argument. But just tell us why in terms of the conduct that this gang was engaged in, why this wasn't substantively unreasonable.
Thank you, Your Honor. So both of the defendants are challenging the substantive reasonableness of their sentences. And this court, based on all the facts in front of it, the district court was certainly within its discretion to decide that these men were deserving of the maximum punishment imposed by law. One thing that struck me when I was reviewing this case, the testimony, both at the sentencing hearings and during the trial, was the devastating effect that the Black mob gangsters had on Southeast Raleigh. They destroyed a neighborhood, and this went on for years. At age 26, Devine had already committed a number of criminal offenses. He'd robbed someone with a sawed-off shotgun, shot someone 4 times, assaulted someone with a weapon, assaulted someone with a firearm causing serious injury, punched a correctional officer in the head causing injury. Then in 2008, at age 26, he became the leader of BMG DGF, which is the gang that terrorized the Haywood Street area of Raleigh. He claimed his territory. And he did so by starting a shooting war with the 9 Treys, forcing them out of their territory. Devine ordered the killings that we know of at least 3 people. Adarius Fowler, Philip Brimage, who survived the attempt on his life, and also Rodriguez Burrell. Adarius Fowler and Rodriguez Burrell both died because of the activities of Devine and this gang. Because they couldn't tolerate, in the context of Burrell, for example, that someone would have the audacity to sell drugs on their block without paying rent. So they arranged to have an 18-year-old's brains literally blown out of his head on his front porch in front of his father and their family friend on Memorial Day weekend. Devine profited from his own drug dealing. He profited from the drug dealing of others. His total offense level, but for the fact that the table stops at 43, it would have been 54. I've been doing this for a very long time. I had to pause to make sure that that number was accurate. He was off the charts. He was an exceptional criminal. He deserved an exceptional sentence.
So the other thing is that the deterrence is one of the 3553 factors. And what chance is there that he's going to be deterred from future activities when he refuses to accept responsibility for this long string of heinous acts, and he's still trying to lead the gang while he's incarcerated for murder? So none of this has deterred him in any way, shape, or form. And there is, if by some fluke he was let out of jail, he'd go right back to what he had been doing. I mean, the district court felt that this was a case of the worst of the worst. And you know what he did visited pain and grief and havoc on so many people and on the city of Raleigh that it deserved a severe punishment. And when you talk about the score of 54, I haven't seen that in a long, long time.
And beyond that, I think that deterrence is important from the broader perspective of general deterrence. When you read the sentencing transcripts for both Mr. Mangum and for Demetrius Devine, the court was concerned about sending a message that one should not aspire to be like either of these men, to control ruthlessly a neighborhood, to mete violence out on anybody who opposes them, to put in work to gain rank in the gang. He wanted to disabuse anybody who had watched this trial or who had been in the gang of the idea that this was a good idea. So while I fully agree with Your Honor that if Demetrius Devine were ever to be released, he would go right back to it, I think that deterrence is also important in terms of sending a message to others. And I think furthermore, there was an interest in sending a message that there needs to be just punishment for these crimes and that these were for the sentence to reflect the seriousness of the offense and promote respect for the law. And those are, more broadly speaking, turning to Mr. Mangum, he also had a history of absolutely unabated violence. And I wanted to highlight, just as Devine had been controlling and operating his gang from behind prison walls, when Mangum was in custody in 2014 or 2015, he was recruiting new gang members. He had been charged by the state for the Burrell murder. That charge had been dismissed. He thought he'd gotten away with it. And that was something that Judge Dever focused on, that he thought he had gotten away with this murder. And it didn't cause him to reflect on his life, that he'd just been involved in the killing of a 18-year-old father of two. It didn't cause him to do anything different. Instead, he was proud of the rank that he gained.
As the VCAR count shows, the way to advancement in this gang is to kill someone, particularly to kill someone at Devine's direction, and particularly to kill someone who was in Devine's territory without paying rent. But this is the way to move up. This is how Mangum got his third star. He was a third-star general. How did he get the star? By killing somebody at Devine's direction.
Absolutely. And the court was well within its discretion to impose consecutive sentences. The court, as to Mangum, he said, as an adult, you have been as committed as a gang member can be. And the court wanted to ensure that he was going to die alone in prison and he and his gang would be forgotten. Does the panel have any questions about either the sufficiency or the severance issues? No. Black mob gangsters in the Donald G. family terrorized Southeast Raleigh for years. Devine and Mangum's trial was the culmination of a decades-long effort to hold them accountable for their gang-related offenses. They were appropriately tried together. There was overwhelming evidence of guilt. There's no double jeopardy problem. And the court was within its discretion to determine that these men, for these crimes, deserve the maximum sentence permitted by law. We ask you to affirm the judgment of the district court.
All right, we thank you. Mr. Ashton, we'd be happy to hear from you in rebuttal, sir.
Thank you, Your Honor. We certainly don't condone what happened. This Hay Street was right in the shadow of the federal courthouse in Raleigh. And I prosecuted in Raleigh for a number of years before I was a defense attorney. But that's not what we're talking about today. The facts are not good. But the question is whether these men who were young at the time could get 3 consecutive sentences for what we contend are just one act. And from a substantive standpoint, we wanted to raise the issue that Vicar is basically a sentence enhancement to RICO, and that 924J doesn't apply because Vicar is a mandatory life sentence. And so procedurally, Mr. Lester will address that on whether that's the proper after that, but we do think we have some substantive arguments because there were really only 2 events to lead to these 3 life sentences for each one of them. One was the murder of Fowler, one was the murder of Burrell. And those are the ones that escalated everything. It wasn't like 3 different people, and neither one of these young men was a shooter either. So from a substantive point, we do want to preserve those issues, and Mr. Lester will address the other issues. Thank you.
Thank you. Mr. Lester, you have some rebuttal.
Thank you, Your Honor. even the worst of the worst are entitled to the constitutional protections and the rule of law. We are not asking this court to overrule Ayala, not asking the court to overrule Love. We think that they're instructive. We're not asking the court to overrule its longstanding, well-established precedent as it relates to Congress's right to offer multiple punishments. What we're asking is the question that Judge Floyd asked the government. And the problem here is where we see where RICO is enhanced from a stat max of 20 to a stat max of life solely because of the Vicar and or other acts that require life. Then essentially what we're talking about is Congress intended to enhance the RICO through the Vicar Act rather than allow there to be multiple punishments. And the reason that Ayala and Love are different is because those cases did not cause the RICO to go from 20 to life.
But you acknowledge that the elements of these offenses are different.
Yes, Your Honor, as it relates.
Once you get in, if the elements are different, there can't be a double jeopardy argument for multiple punishments for the same offense, because these are not the same offenses. And so then it becomes a discretionary matter. Well, and given, you know, in many cases you would say, well, this is very steep, but this is the behavior of this gang and its heedlessness of human life and its unbroken history of violence and the complete mayhem it visited on a large section or a significant section of Raleigh and everything. It just seems to me, if a sentence of this severity was justified, it was justified under these facts and for these two defendants. For many people, no, it would have been out of bounds. But for these two, given all that they've done and the misery, the human misery they've inflicted on a wide scale, how can we say the district court abused its discretion? I don't know. I can't get there.
Your Honor, if I may just respond briefly, that's well stated. And but I think the court requires the district court to articulate why a sentence less than the absolute max is not sufficient. And I believe that the court did not address reasonable arguments, reasonable rationales that I stated in the PSR as to why this individual may have received a single life sentence rather than multiple life sentences. And the failure to articulate that is arguably. He
articulated a lot. He said he gave reasons for what he was doing. This wasn't a silent proceeding. He gave reasons.
Yeah. He gave reasons why a long sentence was required, and a long sentence here would have been mandatory life. And the lawyers and even the government, the defense lawyer asked for a single life sentence, and the defendant, the government even said they asked for a life sentence. And here, the judge gave 4 times, at least to Devine, and 3 times to Mangum, what even the government asked for. And we think that was...
But the government is defending the sentence. That's not the question. The question on appeal is different from the question at trial. The government is defending the sentence to the hilt.
They are. They're defending that sentence. But we're suggesting that under the case law that this court has established, that the judge needed to go further and explain why a lesser sentence was not sufficient, and it didn't do that.
Thank you, sir.
Thank you.
All right. I see that Mr. Ashton and Mr. Leston, you both court appointed, and I would like to thank each of you for your efforts. We appreciate your arguments. And we're sorry that under the present pandemic conditions, we can't come down and shake your hands personally, but we appreciate it nonetheless. Thank you both so much.
Thank you for those comments, Your Honor. We appreciate being invited up here. Thank you.
All right, we'll prepare to move into our second case.
I think it goes without saying that the overall conduct in this case that was directed at Juror A was outrageous and was egregious. But I think the question here that ultimately we need to answer is whether or not the no impeachment rule is going to apply in a way that allows that to take place in this case, as well as in cases going forward. We believe that there's at least two exceptions to that rule that apply here. First, I'd like to address the exception, the outside influence exception. We believe that the legislative intent behind that rule actually supports the evidence of the threats in particular coming in this case. And I would point the court first back to United States v. Tanner, which is a Supreme Court case. We cited that case in our brief for the proposition that the court should have analyzed the nature of the threat, not simply when and where it happened. But what
is the outside influence?
The outside influence in this case, Your Honor, there's actually two that I'd like to focus on. One is the threats that were made against Juror A from Juror B. And those,
how is that an outside influence?
So if I could kind of go where I'm going, I think it might answer that question. So in Tanner on 122 and 123, it gives a really concise description of the legislative intent. And actually what it says there is that the House, when it looked at this rule, actually said that outside influence included threats against someone's family. That's actually specific.
That's not a rule.
Well, I think we would argue that, respectfully, I think we would argue that it is the rule because an outside influence is not simply whether or not it happened inside or outside of jury deliberations. It has to do with the influence upon the juror.
Well, let me ask you this. You often have heated discussions in a jury deliberation, and I guess the problem would be in terms of threats of outside influences. Where do you draw the line? Now, my question to you is, can we draw it with true threats? And I don't really see the difference between a threat to a juror out in the hall or a threat to a jury inside the jury room. A threat's a threat.
Your Honor, I would agree with that wholeheartedly. I don't think there is a difference. I think it operates exactly the same, and particularly in this case where this juror tells us he only voted the way that he voted because he was placed in fear by this other juror.
Well, do we have some discretion to expand the interjury, the impeachment rule? Do we have some discretion to modify that impeachment rule?
I think you do. I don't think you necessarily need to do that in this case. And that is part of why I really started with that legislative intent, because I think what we kind of run into, and I think you even see this in some of the cases, is this conflation of 606B2A and 606B2B. 606B2A is an extraneous influence, let me make sure I state that correctly. An improper, something outside the case that the juror has considered that has to do with the case, such as a newspaper article, such as a radio story on the case, such as something they've seen on Facebook about the case. That is a different analysis from the outside influence. I think in some of the cases, it kind of looks like those run together, and it's very easy to do. I did it myself in going through the analysis. But the outside influence exception is separate. And part of why I point to that legislative intent is because it's silent on who the threat needs to come from. And Your Honor, I think that goes precisely to your point.
So what case do you have that justifies your argument? On point.
Your Honor, there really aren't very many that are on. I haven't found any that are directly on point with this issue.
Well, let me ask you this. Doing a textual analysis, 606B defines outside influence as an influence improperly brought to bear on any juror. Doesn't that place the focus on how a communication impacts a juror and not where it occurred?
Absolutely, Your Honor. Absolutely.
Would that be a stretch in reading it that way?
I don't think it is. And I know that the government even noted in their brief that we were somewhat flawed in focusing on the effect on the juror. But I think under the outside influence exception, I think that's precisely what you need to be looking at. Influence by definition.
Yeah, so let me ask you this. What evidence is there that the argument between the jurors or the friction between the jurors actually reflected any racial animus toward Mr. Brown, or that it affected somebody's vote on the jury? I mean, you can have two jurors who do not get along at all, but that doesn't mean that they took it out on the defendant in any kind of impermissible way. And I don't understand, is there any evidence that racial animus toward Brown motivated somebody's vote here?
No, Your Honor, there's not. However,
Don't we need that?
Your Honor, I don't think we do. Pena Rodriguez is silent on who the racial animus needs to be directed at or who it needs to come from. What it is clear on is the racial animus cannot motivate someone's vote to convict. And in this case, the racial animus, and I'm jumping a bit because this is getting more into the Pena Rodriguez part of the argument, but the racial animus is directed from Juror B and by Juror A's affidavit, at least some of the other jurors, towards Juror A, who is Mexican. And Juror A's, the pressure and the fear that he felt as a result of that motivated his decision to convict.
So where does he say that in his affidavit?
Where does he say what specifically, Your Honor?
Well, you're making the argument in response to Judge Wilkinson that there was some source of racial animus that animated his vote in some way. And so I'm looking at his affidavit, the JA 511, asking you if you can show me where that appears.
Your Honor, I think I would ask you to flip over one page to JA 512 and look specifically at paragraphs 6 through 9. That broadly lays out as specifically as he lays it out, all of what happened in that case. But specifically, paragraph 9, he says, the other jurors were aware of my concerns with the evidence. I was mocked, bullied, and threatened prior to agreeing to vote for a guilty verdict.
So what's that got to do with racial animus?
The racial animus, well, two things. So one, the racial animus presents itself in two ways. One way it presents is that he does say that he was mocked and that he was mocked because of his Mexican heritage while in the jury room. But I think the most glaring example of it is the false Mexican law note that was sent outside of the jury room to the court. Now, that Mexican law note really falls down both tracks here. If we look at this as there's a 606.
What happens if we go back to paragraph 3, where he enunciates, take it, his reason for wishing that he had voted the other way, which is that he had a reasonable doubt because of the lack of photographs, among other things. It seems like you have to make several inferences reading through this affidavit to find that there's a racial content that affected his vote.
Your Honor,
you don't argue that he had any animus toward the defendant.
No, I don't argue that he did. I argue that the animus was directed at him and that he voted to convict as a result of it.
Mr. Pender, I'm sympathetic to your first argument, but really, should we go down the road on the second argument about racial animus? Because the defendant was black, he's Mexican, and this is a bad set of facts to deal with that. It ought to be left open to another day, don't you think?
I think there's not the kind of straight line from the racial animus to the conviction that I think you would generally like to see in a case that's going to deal with this.
Well, that's what bothers me. What I don't want to do is foreclose that issue by an opinion issued by this panel that cuts that off.
Yeah, and
for another day.
And I can certainly sympathize with that. I still want to emphasize the Mexican law note, just with respect to both 606 B2B.
Well, why didn't this come out? Why didn't this come out when the jury was polled? When the judge polled the jury and asked them if the verdict represented their views and set of standard questions, and there was no objection.
Well, Your Honor, I think that what that goes to really is a question of whether or not there are procedural safeguards in this case, which is something that all the other courts that have dealt with these types of issues looked at. And I don't think there are. I think the court has to remember that he was under threat and he was fearful with respect to the decision that he made. And when he was polled, the juror that had threatened him was standing right in the courtroom with him. So there are things that don't show up in the record that if you were there, you would notice. And I know I can't really get into that. I'm the attorney that tried this case, and I'm also the attorney that's arguing. So, had you been there and seen it, I think it would jump out to you more, his hesitation and his fearfulness in speaking up.
One of the things
about that,
I hear that, but one of the things you want to do is avoid a situation where attorneys are trolling for affidavits in the wake of a verdict, because the jurors, they give of their time and they give of some inconvenience and cost to themselves, and after they reach a verdict, I think their whole idea of the no impeachment rule is that they should be able to participate in the workings of the criminal justice system without having it drag on and on and on through subpoenas and evidentiary hearings and questions from attorneys about this and that. And, when you get into the internal deliberations of a jury, a lot of times things are said in a heated fashion. The debates are often impassioned, which I don't think is wrong, because I think that means that people took their obligations conscientiously and seriously. But I'm just worried about juror. You open it up a little bit, and soon the doors open wide. And I'm concerned about just harassment of jurors who've done nothing more than participate in our process, and we need them. And this should not be part of the penalty that they pay.
Your Honor, I certainly understand that concern. I think it's a concern that goes all the way back to the common law in terms of how we deal with this issue. I would just factually point out, with respect to this case, this juror wrote 2 letters to the court. He wrote letters to my office. He essentially tracked us down to tell us that these things happened. Otherwise, we would have never known, because the letter that was sent to the court is missing a page, and we don't know what that page says.
Well,
So
what's in the record in terms of the letter to Judge Jones is, for me, the evidence was not sufficient for all of the charges, in my opinion. There's nothing at all about any type of threat, racial animus, or anything else. So it looks like to me the only thing you have to go on is what you can glean from the affidavit. I mean, what other factual basis do you have?
Your Honor, 2 points on that. One, I think both sides agree that that letter to Judge Jones is missing a page. And it's as to how it was scanned in and filed and documented. So I can't really speak to what Judge Jones saw. I'm not trying to accuse him of anything. I just can't speak.
You're left with the affidavit. That's all you have, correct?
But to that, yes, but to that point, Your Honor, that really speaks to a failure of the district court to develop the record. And I think there were ways that could have been done that would have been less intrusive. One way that I think the district court could have and should have done it would be to have just a special hearing that operates.
Have you made this argument in your brief?
I'm sorry, Your Honor.
Have you made this argument in your brief?
Which
the failure of the district court to develop a record?
Well, I think it's implied by the fact that nothing was done. I have made the argument that nothing was done in this case after the letter was sent. I'm simply saying that had something been done, the record would be more developed. And one of those things would have been to hold a hearing that operates really more almost like a voir dire of juror A, who again sent the letters to the court, sent the letters to us to dig into exactly what happened in that jury room.
Well, did you ask for that hearing?
I did not at the time, Your Honor, but I would point out that by the time I'd gotten it, then my mind was on the motion for new trial and an evidentiary hearing. I'm simply saying that's something the court could have and maybe should have done to develop the record a bit more. At least then we'd be able to say for sure exactly what happened in the jury room, besides just what's in the affidavit.
Well, thank you, counsel. We look forward to hearing from you in rebuttal.
Thank you, Your Honor.
Ms. Brocklehurst, I think it is. We'd be pleased to hear from you.
Thank you, Your Honors. Your Honors, I think that the key point here is that the court actually was not authorized to conduct the hearing now proposed by counsel, because the very heart of the impeachment rule is that you do not delve into the statements and incidents that occurred during jury deliberations between the jurors, the effect that such statements and incidents have on the jurors and their votes or their mental processes. And that is exactly what this case implicates. It does not implicate outside influences. It does not implicate racial animus tainting the jury verdict. I think counsel is correct that there's a conflating of extraneous prejudicial information and outside influences. But regardless of which one of those two prongs you look at, the statements alleged in the affidavit to have occurred do not constitute any kind of outside influence, which would be defined as anything brought from the outside impacting the jury. At best, the affidavit alleges intimidation. He uses the word threatened at one point in his affidavit, but in fact, when you look at what he says, at some point, juror B told me, I know where he lives. At some point, juror B discussed that he owns guns. And then later during deliberations, he became aggressive. The law is clear that aggressive posturing by a juror is exactly the kind of statements and incidents in the jury room that the no impeachment rule it is directed at. And as Judge Wilkinson has acknowledged, we presume the Supreme Court has recognized that jury systems are a system involving people and they are not going to be perfect. And one would expect if you put 12 people in a room and tell them to make a decision, and it's a small room and they know they cannot leave until it's done, people are going to get loud when they disagree. They may get forceful and a person may feel intimidated. That does not mean that the behavior of the juror that is the source of the intimidated feelings is behaving in a way that is an affront to the justice system.
Well, ma'am, including Tanner, aren't courts concerned how interactions impact jurors and not the mechanics of those interactions? For example, this is hypothetical. Obviously, if somebody pulled a gun on a juror on the way home, that would be a threat you wouldn't argue about. But what if the same thing happened in the jury room? Does the place where it happened make a difference? Because the act is the same.
Well, I would suggest that were to occur in the jury room. The answer is not that the gun itself may be an outside influence, but let's say it was words. I'm going to kill your daughter if you do not. The way that the court would need to get at that is not that an outside influence was brought to bear. It is that there is potentially an exception, and it has been alluded to by the Third Circuit in the Lacani case, which was cited in our district court briefing, that if there is a coercive threat or something with the coercive effect of a threat or bribery, that may itself either constitute some kind of extraneous information or would be its own independent Sixth Amendment problem. But shoehorning language that intimidates a juror into the outside influence exception, which is clearly meant to be that something, some piece of information or some act that is outside the context of the communications between the jurors themselves. And that's what is happening here. We're trying to shoehorn these statements into the outside influence.
One thing is the bottom line. One thing that I asked myself is whether there's any evidence that the jurors voted to convict Mr. Brown out of racial animus or for an obviously impermissible reading. And I don't see that. You have to, no juror has testified to that, and you have to, it has to get pretty speculative to think that somebody actually had their vote in the case to convict influenced by this exchange that occurred in the jury room. Now, the exchange was not an admirable one. It's not the way we hope people communicate, but as you put out, it's a jury deliberation often isn't a nice little tea party. People care. But I don't see how, at the end of the day, somebody voted to convict this defendant on the basis of the conversation that took place.
I think that's exactly right, Your Honor. And I would point to, in support of that, the distinction between the note about a juror is trying to apply Mexican law and the other intimidation that may have occurred in the jury room. That note suggests some misunderstanding potentially of what he was trying to argue in support of why there was not enough evidence. But it is not a clear statement of racial animus. It is not a clear statement of racial bias. And it certainly does not meet the test of establishing that racial stereotypes or racial animus were a significant motivating factor in the jury verdict. It requires a chain of suppositions and analysis to get to any kind of conclusion that the fact that there was a Mexican juror who was disagreeing with the rest of the jurors somehow taints the verdict and makes us concerned about racial animus in the jury room. And so I would agree with Your Honor. I think there's no application of the Pena-Rodriguez exception that would apply here. And this court has already acknowledged that that exception needs to be construed narrowly, and it needs to be based upon clear statements that establish significant motivating improper factor led to the verdict. And
I asked Mr. Pender this question. A threat is a threat, whether it's made outside the jury room or inside the jury room. Why do we, where's the logic in that if it's a true threat that impacts the jurors' deliberations?
so if there were a true threat that impacted the deliberations, then the verdict would be based upon, or at least that juror's vote, which is necessary to the verdict, would be based upon a fact that was completely unrelated to the evidence in the case. It would be based solely upon the fear of the defendant of that threat being acted upon. And if the case involved a true threat, I think there would be potentially a very different outcome to this case. But there is no true threat in this case.
Well, he actually, there's more to it than just the two things you said. He actually got in his face and puffed himself up. Along with whatever he said.
So there's a distinction between threat and intimidation. And frequently in criminal law, when we are talking about threats and intimidation, we lump them together.
Well, don't you view it from the eye of the victim and not the defendant?
In many instances, yes. But here you're talking about undermining a core tenet of the Anglo-American legal system. And every case that has acknowledged exceptions requires clear statements, clear evidence that something improper happened. This affidavit is not clear evidence of that. One interpretation is he said, he told me he knows where I live, he has guns, and he puffed up in front of me, and that made me scared. But this was a 3-day jury trial. And a very reasonable assumption is they walk into the room together and juror B says, hey, I know you live down the street, or you live in my town, I know where you live. So that is in the back of juror A's head, but there is absolutely no intent on juror B to equate those things together. A comment that I know where you live and, oh, hey, I really love my guns, it's Southwest Virginia, it's not a common conversation.
That actually defies logic. He's Mexican and the juror's white. I guarantee you there's no relationship between them.
Well, and the statements don't suggest that there is, only that he knows where he lives. I mean, it's a rural area. You frequently know where your neighbors live, even if you don't know them. And he doesn't allege that juror B said, I know you. He just recognized him from the community. And it requires you to deduce, I think, to find that this statement is a threat requires you to put together a string of suppositions that are just not supported. The law does not allow, I would submit, for a string of suppositions to establish the kind of clear statement to overcome the impeachment rule. The impeachment rule is 237 years old, and this court has said, courts over and over again have said that what you are looking for is something that is an affront to justice.
Does the timing of this matter as well in terms of whether the district court abused its discretion? How long after the trial had concluded? What time elapsed between the time the trial had concluded and the time that the affidavit was signed and submitted to the attorney?
I believe it's about 4 months.
4 months.
The letter came within a week or so of the end of the trial in September, and the affidavit was submitted, I believe, in January.
There was a thorough voir dire in this case?
Yes, sir.
And there was a poll of the jury?
Yes, sir. And instructions repeated twice that jurors are to find their own verdicts. And The juror A is clearly on notice. He can pass a note to the court security officers if there's a problem. If your honors have no further questions. Thank you.
Excuse me, Judge Floyd, do you have some further questions of counsel?
No, sir.
Judge Agee?
No, sir.
I don't as well. Thank you very much.
Thank you.
And we, Mr. Pender has reserved some rebuttal time, and we'd be happy to hear from you.
Thank you. Thank you, Your Honor. First and foremost, I would just like to point out the fact that there's really no procedural safeguard. There's no amount of voir dire that would negate a threat. I just don't know what question a judge could ask during voir dire that would allow us to strike a juror based on the fact that that juror is going to threaten another juror. And so I just think that that needs to be pointed out. And I think what also needs to be pointed out is the Mexican law note was racial animus because it was false. Now, whether that fits the Pena-Rodriguez argument, I think most likely that issue is settled here. But I do think when you consider it in the context of the threats and the pressure put on juror A, it's still relevant. It was racial animus precisely because it was not true. And he was the only Mexican man on the jury. And the jurors knew that when they sent the letter.
So what is your best case for a Rule 606 argument?
The threats against the juror, two, the threats against the juror and the note which was sent outside.
So, but what's your best case?
Oh, in terms of the law. Your Honor, there's.
That's what we're doing here is the law. So what, you have a case that you want us to look at in particular?
I don't think there's cases that are helpful either way. I think actually, if you look at the analysis in Pena-Rodriguez, though it deals with racial animus, it falls along the lines of what we're talking about here with respect to the threats. Because I think when you get to the basis of it, where it really starts is going all the way back 170 years and going back to United States versus Reed, in which it said there are certain situations that violate the plainest sense of justice. And I think that a threat towards a juror is certainly that kind of case. And I would also, again, point the court back to Tanner in the legislative intent, because I think that's important here. It specifically says that threats against someone's family would be an outside influence. And so I think if we're looking at this as a threat, and if we're looking at the affidavit, that's the only way I think you can look at it, because he says he was threatened. Then I think wherever threats fall on that spectrum of inside versus outside, they certainly fall more on the outside part of that spectrum. I think the court and the government here kind of persist in this really rigid distinction that because it happened in the jury room, it's not an outside influence. The law specifically says not to do that. And I think if you look at the court's opinion below, it doesn't have any other analysis of the threat other than I'm not going to consider it because of when it happened. That is where the abuse of discretion is. Had the court said, I'm not going to look at it because of when it happened, but I also don't think it's a threat, and I also don't think it's X, Y, and Z, maybe we have a different conversation. But the only thing in there is because of when it happened, I'm not going to consider it. Our point is that is the rigid distinction that the cases speak against. So actually, if I can, I think I'm going to backtrack a little bit. I think my strongest case is actually Tanner because it makes that point. And so if I had to point the court one place, it would be United States v. Tanner as to the Rule 606 B2B argument. And it would be specifically the legislative intent in that case, as well as the analysis of the outside.
Well, you know, speaking in terms of this outside inside, a lot of times jurors will bring their personal experience and background into a deliberation. And that's kind of unavoidable. And we have cases where there was a Bible reading, and we have cases where someone was intoxicated, and we have cases where someone was sort of a juror dozed off, and then there are other cases inevitably where jurors are going to speak from their background, their own background and their own personal experience. But that doesn't necessarily make it an outside case, because jurors are inevitably going to be taking their personal characteristics into the jury room. That's why we have juries, and that's why we want to have juries that represent a cross section of the American public. And I just worry about anytime someone brings their own background and experience and expresses that in a jury discussion, that makes it an outside influence. I don't think that's true. What do you say with respect to that, sir?
Your Honor, I say that with respect to that, in this case, the outside influence was the threats. The things that the courts described.
But how it has to be, I think part of the district court is not, he doesn't think it's a threat.
Your Honor, as I recall, I don't believe the district court said that, though. I think what I recall the district court saying with respect to that argument was, I'm not going to consider it because of when it happened. The district court never said it wasn't a threat. The government has argued that it's not. The district court didn't analyze it at all. It said because of when it happened, I'm not going to consider it. That's what we're arguing was the abuse of this.
But if it had been construed as a threat, then there might have been a different result. But the way that the district court ruled would almost presuppose that he did not consider it to be a threat, or at least a threat at least a threat or something that influenced the vote. I come back to the basic point I made, and that is at the bottom, at the end of the line, we want to make sure that Mr. Brown received a fair trial. And I don't understand how the discussions in the jury room deprived him of a fair trial. One can make all kinds of speculative inferences about it, but wouldn't you need something more concrete?
No, Your Honor, because Juror A is telling you that he was not impartial because he was threatened. So I think that's what we're really going to. He didn't have an impartial jury. Now, what happened before that, I don't have any argument with that, and I don't even have an argument with the court's, instruction to the jury after the fact. No more than we knew at the time. I think it's the best the court could have done. But Juror A has made it very clear he was not impartial because his vote was not his own. He only voted that way because he was threatened.
Excuse me, counsel, if it's an interesting argument, so I want to give you some extra time here, but if we take your view of it, of what the affidavit said, and we took your view, wouldn't that just become boilerplate for all kinds of future affidavits? And lawyers would say to counsel, here's what you need to put down. We've got this case out there that says because of my because of this threat that was made, or because of this intimidation that was made, it affected me. In other words, this would be boilerplate for innumerable claims that would compromise the privacy and unimpeachability of jury deliberations. That's what concerns me, is that a lot of times people say, oh no, this is a one-off, or this is a singular case. But I'm not so sure. It seems to me that once you breach that wall of non-impeachability, you begin to open it up to a pretty significant extent. I'm just explaining what my reservations are, and I've taken your time with my question, so I want to give you a chance to respond.
Your Honor, I appreciate you allowing me to respond to that. That is a concern that I think any litigant that's being fair understands. And I certainly understand that. But I think exceptions to the rule exist for a reason. And I think we do have to be careful to say that for simply because of finality, we're not ever going to apply 3 statutory exceptions that exist and at least 1 court-made exception that exists, because we're afraid that lawyers will track down jurors and get affidavits and make up things. For one, I think there are other ways of dealing with that, one of which is if a lawyer did that, it would be unethical, and they'd probably lose their license if they went to a jury and said, hey, lie, make this up so we can get this verdict up over. So, I mean, I think you have things in place to address attorneys doing that. But I think you have to be equally concerned, if not more concerned, with what you message to the public, to people who are charged criminally, that the only right that they have, the only thing that they can exercise is to look at the government and say, put 12 people in that jury box and prove it. There's already a chilling effect on that because of the well-established federal conviction rate, mandatory minimums. That's a different conversation. But how do I advise a defendant that you should exercise your right to trial, particularly in a place like Abingdon, Virginia, which, God love it, has very little diversity? How do I advise a defendant to exercise that when they've got to look at a situation like this and say, well, I'm lucky if I get one person of color on the jury. And if the rest of the jurors act this way towards this person, if they threaten this person, if they send out notes, nothing will be done about it.
Well, I started out with this true threat analysis. All that would happen in this case is we send it back for an evidentiary, and the judge will make a decision whether it's a true threat or not. If it's not a true threat, case over.
Your Honor, I think that's correct. I know I've asked for more than that, but I think that's correct.
Well, you might not get that either.
Yeah, I recognize, Your Honor, and I recognize that at the time. But were it to go back, and that kind of gets to Judge Agee, what I was talking with you about earlier, it would at least develop the record more with respect to that, if nothing else.
All right, thank you very much. Judge Agee, do you have any further questions?
Yes, sir.
We'd like to thank you both for your arguments, and we appreciate having you here. Sorry we can't come down and shake your hands, but we're appreciative nonetheless. And if we may, I'd like to go into our final case at this point.
Judge Wilkinson, do you mind if we take a very short recess?
Oh, sure, we'd be delighted. We'll take a five-minute recess and then reconvene, okay? That'd be great.
Water.
The Honorable Judge of the United States Court of Appeals for the Fourth Circuit.
All right, we're ready to begin our final case. And Mr. McCoy, why don't you proceed when you're ready?
Thank you, Your Honor. I'd like to reserve 2 minutes for rebuttal. May it please the court. My name is Robert McCoy. I'm a criminal defense practitioner litigating civil or criminal and civil matters out of state and federal courts in Wheeling. And I have the honor of representing the appellant, Ricky Runner, in this matter today. Mr. Runner was the subject of an illegal search of his vehicle by Moundsville, West Virginia Police Department officers because they viewed what was clearly a legal item, stem pipe, in the console of his vehicle, predicated their ensuing search of that vehicle exclusively on the presence of the pipe and the pipe alone to justify their search. Because the district court erred in denying Mr. Runner's motion to suppress, we respectfully request that this court reverse the district court order denying that motion and remand the matter for further proceedings. This court has never held or appeared to have even considered the propriety of a search on a plain view basis that was based exclusively on the observation of what was termed paraphernalia. There has always been, in every case out of this circuit, something other than, over and above, the existence of the paraphernalia, some suspicious activity, the presence of powder, other drugs, a litany of reasons, all of which are furnish or elevate the quantum of evidence that gives or vests the officer with. Are
you saying that the observation of scales or what have you that be or cutting agents, etc., even if they were not the contraband itself, that would not support a plain view search?
Yes, Your Honor. And again, it would turn on the specifics, the facts of the case. If, for example, you saw syringes and cutting agents, or you saw digital scales and cutting agents, or digital.
What I'm wondering is whether you're arguing for an absolute rule that says you have to spot the contraband itself, and that it's not enough to scales or cutting agents or syringes.
Not at all, Your Honor. There's no suggestion whatsoever in this argument that the contraband itself would have to be observed in order to furnish the officer with probable cause to search.
Well, one of the deputies at the search was a drug recognition officer. He testified at trial that these pipes are often used for methamphetamine. He had that knowledge.
Well, I'd like to bring a couple of things up on that point. One, he claimed to be a drug recognition expert, but he was never offered by the government as a drug recognition expert, and he was certainly never recognized by the court as a drug recognition expert.
Did you object his testimony?
I did not, Your Honor, but I wasn't offered the opportunity to object because the government never offered him as an expert. The court never inquired of me as to whether I had an objection to his recognition as such. With respect to Patrolman Schilling's testimony about the stem pipe, certainly a stem pipe is a means of using or smoking illegal narcotics. But in this particular case, that is the sum total of all the evidence that he saw was the presence of the pipe.
So why isn't that sufficient?
Well, for several reasons. One, the pipe has alternative lawful uses, and the record was developed, although ignored largely by the district court. The record was developed with a witness who was brought in who sells thousands of pipes over the years. In fact, he testified that in the 8-month period up in the calendar year 2020, the 8-month period between January and August of that year, just before when the suppression hearing in this matter was held, that he had sold 1,000 pipes in his CBD store.
I thought one of the officer testified he wasn't aware of that use, but he did testify, as Judge Floyd indicated, that based on experience and training, that this was a drug paraphernalia item. There's an Eighth Circuit case, Van Z, that seems to be almost identical to this case.
Regrettably, I'm not acquainted with that Eighth Circuit opinion, Your Honor. But what I would say is that the stem pipe at issue here is also used commonly, according to the witness who testified on Mr. Runner's behalf, the fact witness, Mr. Schmidt, is commonly used to smoke CBD oil. And with the advent of CBD sales to sell hemp and CBD oil for smoking, what might have constituted probable cause 30 years ago certainly doesn't rise to that level today. Without more.
Well, why now? Well, I mean, why did they need to go beyond probable cause, which is not that high of a showing? That seems like to me you're almost arguing that there's a knowledge requirement on behalf of the police officer.
Your Honor, what I'm suggesting is that the quantum of proof in the officer's possession should certainly exceed merely observing a piece of paraphernalia. Paraphernalia is not unlawful to possess under West Virginia law. In fact, it's not even unlawful to sell. Okay? And without more, and every case from this circuit includes a with more component. So, for example, it's an unpublished disposition. The closest I could find.
Well, is there a case that's found where you have a single item such as this, that failed to show probable cause?
No, I guess that's the reverse side of the question. No, Your Honor. But every case that was upheld, where the search was upheld, there was a with more quantum of evidence. Are you familiar with the Eighth Circuit's decision in Muniz? Yes, Your Honor.
Well, I mean, that case seems to be pretty close to this one as well. It's not as factually on point as Van C, which is the published opinion. But the Eighth Circuit seemed to be of the view that a circumstance like this was sufficient in and of itself.
Well, if this court adopts a standard that just viewing, for example, a pipe in the console of a vehicle without more justifies a search, then it will be making new law relative to the opinions that it has handed down thus far. And it would also, so for example, if someone had a syringe in the console of a vehicle who was an insulin dependent diabetic.
Well, did the officer testify here about what his training was?
Yes, he did. He said that he was acquainted with stem pipes being used to smoke.
So you have more here than just the observation of a pipe. You have the additional knowledge testimony from the training and experience standpoint of the police officer.
Well, yes, and it's not a contested point that a stem pipe can be used to smoke methamphetamine, but it has other lawful uses. So, for example, a syringe in the console of a vehicle could be used to inject heroin or other illicit narcotics, but could also have a lawful purpose in the sense that it could be used for dispensing insulin. Similarly, rolling papers, for example, can be used to roll marijuana into cigarettes. So take loose marijuana and roll it into cigarettes. It can also be used to roll tobacco. You could have a firearm, for example, in the console of the vehicle. And a firearm could be used in a robbery or anything else. Okay? It could be used in a homicide. But without more, that firearm does not rise to the level of probable cause just by itself. And in this case, the district court did everything that it could to cobble together as many innocuous, innocent facts as possible to try to sew those into some nefarious conclusions, that these people were at the Walmart parking lot at 1:30 in the morning when the store was open and they were patronizing the store. So, I mean, you could take the pipe. I mean, if you want to say that the pipe is by itself rises to the level of probable cause sufficient to justify the search, then that would also authorize law enforcement officers to go into vehicles if they see, for example, other innocent things without any additional evidence, rolling papers, syringe, a fire alarm, and you'll get to the same result that the officers did in this case. So I wish to point out that the government has attempted to elaborate on the district court's finding by saying that there's more than just the pipe. There's repeated references to the circumstances that bring the officers to the parking lot in the first place, which is the anonymous call. That has zero weight. It was an anonymous call, and the caller's information was not corroborated in any shape or form. It was, in fact, contradicted in virtually every respect. The only evidence that justified the search was the officer's observation of the pipe. That and that alone. So if that becomes the basis for
why wouldn't the 911 call be something more?
That's an excellent question, and the answer is that the caller's information was, first of all, anonymous and furnished no evidence at all that was corroborated in any fashion at all, beyond the fact that there was a woman exiting a blue Volkswagen. There was, in fact, the caller's information by the officer's own.
The 911 call said, talked about a person shooting up. How much detail was there in the 911 call?
Based on the record and the officer's testimony, that was it. There's a woman in a blue Volkswagen in the Walmart parking lot shooting up.
Well, all right, but I mean, the 911 call wasn't about somebody shooting up in Alaska. The 911 call must have given the location.
Well, that's true, Your Honor, but this court said in Foster and some other cases that the proof of innocent facts in and of themselves don't give rise to a finding of probable cause.
No, but the question I'm having is that you say all of these something mores were just make-weight arguments and everything, but I mean, this search took place at 2 a.m. in the morning in a parking lot. There was a 911 call about a person shooting up, and there were track marks on the passenger's arm. I don't understand why that wouldn't provide context for the pipe. I mean, that's a very late hour in a very isolated location, and the only reason the officers were there looking into the car had to do with the 911 call.
Your Honor, the caller's information was contradicted in every imaginable respect. First of all, it wasn't an isolated location. It was a Walmart. It was in the parking lot of a rather sizable shopping plaza. And the Walmart itself was open for business. There's nothing particularly nefarious about patronizing Walmart at that time of the morning. It was a closed business. That might be a different story. It might compel a different conclusion, but this is a store that was open for business.
It's true that if you are doing this, if you're into shooting up, and the pipe is used for nefarious purposes, you're less likely to be observed if you're doing it at 2 a.m. in the morning. And of course, part of the deal here, part of what the occupants of the car were considering is that they wanted to conduct their activity in the greatest secrecy possible, and 2 a.m. would seem to be a good hour to do that.
Certainly, that's true. But in this particular case, the young lady in the car said she was applying her makeup. The officers confirmed that she was made up, and they observed makeup bags in the car. The officers acknowledged that everything supplied to them by the anonymous caller, other than the location of the car and that a woman was there, was contradicted by what they had observed. Someone who's just presumably injected narcotics would begin to exhibit the symptoms of someone who was impaired. And the officers acknowledged repeatedly that this woman was not only not impaired, she was not evasive, she was engaging, she spoke to them. You can watch in the appendix, there's the video. She's very friendly, talks to them, she's cooperative, she's not plainly not high. Everything that the caller said was contradicted by what the officers had observed. And they apparently were not satisfied with her explanations. They saw no indicia whatsoever. And even the pipe itself contradicts what the caller said. Someone doesn't use a pipe to shoot up. Okay, the caller said someone was shooting up in the car, injecting narcotics, presumably. And all that was observed was the pipe.
Is the district court due some deference here? I mean, you're drawing one set of inferences from the facts, and the district court apparently drew another set of inferences from the facts. And isn't the person that actually conducted the hearing, the suppression hearing, due some deference here?
Yes, there's a clearly erroneous standard on factual findings. That's certainly true. But the thrust of this argument is based upon the legal notion that the pipe itself furnished probable cause. That was the crux of the district court's order. That was the testimony of the officers, the acknowledgement that the pipe and the pipe alone and nothing more furnished the basis for the search. That was the officers' acknowledgement, that they had nothing else that justified conducting that search.
Well, all I can say is the officers didn't just parachute into the parking lot. They were there because of a particular call, and the caller had observed the suspicious activity. I mean, that was the whole reason they were there. They didn't just happen upon this car.
Respectfully, the caller's information is fiction. There's nothing that the caller said that was corroborated in any shape or form.
Why wouldn't the pipe be a corroborating factor?
Because the caller said that the occupant of the car was injecting drugs.
All right, counsel,
Thank you, Ron.
we appreciate your argument, and you've also got some rebuttal time that you've reserved. And we're now prepared to hear from Ms. Lemon.
Thank you very much. May it please the court, I'm Danae DeMacy Lemon, representing the United States in this matter. When you view the evidence here undertaken in light of the specific context of this case, as opposed to the general proposition that there's just a pipe in a car, then the evidence does not show a definitive mistake was made, a conviction that a definitive mistake was made by the lower courts here. The incriminating nature of the pipe in this case was immediately apparent to officers based upon their testimony and based upon their training and experience. We don't have just someone law enforcement officers walking down the street and just seeing a pipe on the sidewalk. We have an anonymous caller, granted that caller was anonymous, but the tip was partially corroborated here. The caller states that they see a blue Volkswagen. What does police find? A blue Volkswagen. The caller states that the person in the vehicle injecting drugs is a female. They find a blue Volkswagen with a female in it. This is 1:45 in the morning. She identifies herself as Miss Garlow. She has what she testifies as old track marks on her arm. So there's some type of indicia of some type of drug use, whether it was recent or not. Corporal Schilling on Joint Appendix page 120 states that when he walks around the car, he sees a container with powder. He asks about it. She states that it's a makeup bag. And the point here is that the tipster observes drug use in some type of form. And after the search, there's evidence of drug use in the car. In that makeup bag, they find Xanax pills and what they suspect to be crystal methamphetamine.
So what do you make of Officer Muchek's, that's how you pronounce it, testimony at page 36 of the appendix, And counsel has gone through with him the encounter with the young lady in this case, gone through most of the things you've recited, and then he asked him, but would you agree up to that point in time, you certainly didn't have any basis to search the vehicle? And he answers at that time, no. So are we entitled to look at any of the circumstances other than the presence of the pipe and the officer's knowledge and training testimony?
I believe so, because when Corporal Muchek made a circle around the vehicle, he did not see anything. It was Corporal Schilling. He came back to Miss Garlow, who he agrees did not appear to be under the influence of anything. But we do know at that point that there was another person in the car that is now in the Walmart, who is Mr. Runner. So based upon the evidence of what the officers have there, they're making a conscious assessment of this tip, because it technically could have been, we don't know what the caller saw. It technically could have been Mr. Runner in the car doing some type of narcotics. So the tip, I believe that we need to look at, because there's some type of indicia of reliability. I'm sorry.
Let me ask it a different way.
Sure.
Do you need anything else other than sighting of the glass stem and the officer's knowledge of its use? Or not knowledge, but education and training about what they're used for?
Given the context of this case, no. They're in a place where they're lawfully allowed to be. We know from Katz that what anybody exposes to the public, even in his own home or office, is not subject to Fourth Amendment protections. They see this pipe. They both testify that this type of pipe, based on their training, based on their objective training, this probable cause standard of their flexible knowledge and training at the time, they both testify that they have a reasonable belief that this pipe is contraband or evidence of a crime. I believe that Corporal.
Can't we take into consideration how the officers came to be there?
I'm sorry, I didn't hear the first part of the question, please.
I'm sorry. Can't we take into consideration how, why, and how the officers were there? What led to them being there? I mean, that's part of the narrative and it's part of the story.
Right. See, that's where my argument is, that this case comes down to context. They're not just there because they're there. They're there because of an anonymous caller at 1:45 a.m. making a complaint about someone injecting drugs in a vehicle. So when you take the context of this case and you take officers' training and experience in this case, even given Mr. Schmidt's testimony on the record that the most common way, which Mr. Schmidt was the defense's witness, the most common way, he says, to ingest CBD oil is through oral drops. He admits that hemp flower is not used for smoking, but some hemp oils can be used for smoking. So officers' training and experience there, they're not aware of smoking CBD oil through this type of pipe. And I believe that Corporal Schilling stated on page 71 of the record that he's aware of bongs used to smoke oil, not glass pipes used to smoke oil. And he had certain training with respect to these glass pipes. And so there, at that scene, on that location, at that time, these officers believe, based on their training and experience, that this constitutes evidence of a crime. This is not Foster.
I take it that you believe that probable cause is just the probability of criminality. Is that
correct? It's a probability. They don't have to know at the scene. Texas versus Brown's Green Balloon tells us that they don't have to actually know at the time that they see something that it's absolutely 100% used for illegal drugs versus CBD oil. They are reasonable as long as they have probable cause to associate that pipe with criminal activity. And in Moundsville, West Virginia, at 1:45 a.m. in the morning, based on the record of what they saw, they did believe that they had probable cause to seize that because the incriminating nature was immediately apparent to them. In West Virginia, CBD oil is only legal to a certain percent. So THC is only legal to about 0.3%. Officers would have no way of knowing whether or not that pipe was used to smoke something legal or illegal based on that THC percentage when they were standing outside of the car.
Are you familiar with the Eighth Circuit's decision in Van C?
Van C?
VAN, separate word, ZEE.
No, Your Honor, I apologize, I'm not.
It's a published opinion that's almost identical to this case. And finds for the government, almost on exactly the same evidence.
This, Mr. McCoy akin this case to the Foster case. And I want to state that this case is distinguishable. The facts in this case, the context are distinguishable. This isn't a set of innocent facts. Mr. Foster was sitting in a vehicle across from a restaurant where a detective came out at 1 p.m. in the afternoon. He was having lunch with his wife. It's not some type of high crime area. They approach Mr. Foster. The detective knows Mr. Foster is up to no good from some type of previous arrest, or he believes that Mr. Foster is probably up to no good. And then surveillance.
All I want to make clear is I do not believe, or do you believe, that we are precluded from taking into account the 911 call and the whole question of why the officers were there in the first place, and the whole question of what the hour was. In other words, it's not just, to me, what's important is it's not just a pipe in isolation. It's a pipe surrounded by a context, and the context here is not especially favorable to the defendant. But there's nothing that precludes us from taking into account that context. Is there in terms of a plain view search? I mean, you could, I suppose, the argument can be made, oh no, the only thing that you're able to take into account in a plain view search is what you see in plain view, and whether that was incriminating or not. And the question that I have is, why in a plain view search can't the incriminating nature of the pipe be informed by context? It's just unnatural to isolate one part of a sequence of events from others. And I think your worthy opponent is saying this is the pipe alone, and that's all you can look at. And what I'm suggesting is that, you know, basically when officers undertake a plain view search, what they see in plain view that gives them probable cause to search is necessarily informed by what goes on beforehand, which is, you know, why are they there and where are they? Those kinds of things. And I assume that's your view.
Yes, Your Honor. That's why I mentioned the context. It's kind of why I mentioned Foster, because the Foster context of that case is different than the context of this case. And based upon all of the evidence, the totality of the circumstances here, the 1:45 a.m., the phone call, the easily identifiable Volkswagen and female, the old track marks, the container of powder, and then the officer's knowledge.
But all I'm saying is that if they had arrived suddenly in a parking lot at 1 p.m. in the afternoon, and there'd been no 911 call, and they'd seen the same thing inside the car, this would be a very different case, wouldn't it not? Would it not?
I agree. I agree that it would be a different case because I think it boils down to context. If this were 1 o'clock in the afternoon, let's take the glass pipe itself. It's used to smoke something. If it's 1 o'clock in the afternoon and officers see a glass pipe somewhere else, somewhere maybe in a store, if you can go into a CBD oil store and there's a bunch of glass pipes on the counter, on the table for sale, they're illegally for sale, that's nature's not incriminating. It's not immediately apparent that it's incriminating and used in a crime. But pluck that same pipe, take it off the shelf and put it in Mr. Runner's car with the facts that we have now and the context that we have now it is immediately apparent.
No, and what I think you're driving at, and I think, is that you cannot get away from context, because that is what the officers are acting on. That is what any reasonable officer would act on, context. And, you know, as I say, without the 911 call and in the middle of the afternoon in broad daylight, it's a different case because there's a different context.
That is what I'm getting at. Thank you, Your Honor. This is about context here. The tip was partially corroborated. This isn't a set of just innocent facts here. And there was indicia of drug activity here in this case. We have cases that involve even a cup of water. It depends on the context. U.S. versus Turner, the defendant cited, it's actually a civil forfeiture complaint of a Corvette. But the whole impetus for that search of the officer following that woman out of a convenience store was that she got a cup of water. And he went out there, and in his training and experience, he believed that the cup of water was used to cook drugs. He looked around and saw what he believed were drug items once he had accosted her. But so that's an innocuous item. So it's based upon the context of what's going on here in this case. And I don't think that we can just ignore the 911 call because it wasn't fully corroborated. It was partially corroborated here.
Okay. Is there anything further that you have?
No, Your Honor, other than the cases I cited in my brief. As we know, an innocent explanation here, because it could possibly be used for CBD oil, does not vitiate properly established probable cause. And again, there's no clear error because the entire evidence, including the 911 call, including officer's testimony, and including Mr. Schmidt's testimony, does not show a definite conviction that a mistake was made by the lower courts here. Thank you so much.
All right, thank you. Let me hold on a minute. I want to see if either of my colleagues has further questions for you. Judge Agee, do you have any questions?
Yes, sir.
Judge Floyd, do you have further questions?
No, sir.
All right, we thank you very much. And Mr. McCoy, you have some rebuttal time, so we'd be happy to hear from you in rebuttal.
Thank you, Your Honor. Your Honor, the court seems to be concerned about the context, and I think that's a very fair consideration. And I think the context can certainly take something that's otherwise an innocuous and innocent fact and elevate the degree of suspicion to the probable cause level. But in this particular case, on these particular facts, it's not justified. The context doesn't do anything to elevate the amount of proof in the possession of the officers. It's an anonymous call. The caller did not affix her or his name to the call. They didn't back up the allegation with the imprimatur of their identity. The caller's information corroborated purely innocent facts of a female in a blue Volkswagen in the Walmart parking lot. Those are innocent facts. The business is open. People work shift work, shop at Walmart at that time of the day or night, or all times of the day and night, including at that time of the morning. People who are insomniacs go out and do their shopping at times. People who don't like to be around other people who go and do their shopping at that time. There's nothing nefarious about being in the Walmart parking lot at that hour of the morning.
Do we know where in the parking lot she was parked?
One can observe that from the video, Your Honor. It is, it's in the joint appendix. It's not that far from the entrance. It's fairly close to the
entrance to the store.
Yes, Your Honor. What we're going to do if this search is upheld is put individuals who patronize the Walmart in the middle of the night at a higher degree of suspicion for other activities. If there was more in context here, that might justify the search. But again, it warrants repeating that the caller's information was contradicted in every respect. The female was not under the influence of narcotics. There was no indicia of injecting drugs. Okay, she wasn't high, she wasn't evasive. And again, Your Honor, put your finger right on it when you said that this is about the pipe. It's just about the pipe. You can use context, but in this particular case, the context does nothing to elevate the degree of suspicion that would have justified this search. So we ask you respectfully to reverse the.
All right. We thank you very much. And I want to thank both of you for your argument, and you've been a great assistance to the court. We wish you a pleasant afternoon. And I'll ask our courtroom deputy to adjourn court and to put us in our conference.
Judge Wilkinson, before we go, did you want to note Mr. McCoy is court appointed as well?
I certainly do want to, Mr. McCoy, I really want to tell you how much we appreciate your taking on the case in a court appointed capacity, because we really do depend on our court appointed attorneys to make a fine argument, and you've certainly done that here.
Appreciate that very much. Thank you.
Conference in here.